How do the Fifth and Sixth Amendments protect the rights of criminal defendants? What is the relationship between the right of trial by jury to the natural rights philosophy and to the principle of limited government? One of the rights guaranteed in the Sixth Amendment is the right to a public trial in all criminal proceedings. What purposes are served by public trials? You may begin.
Stated by Thomas Jefferson in his inaugural address of 1801, I deem one of the essential principles of our government, and consequently one which ought to shape its administration, equal and exact justice to all men. In the Bill of Rights, both the Fifth and Sixth Amendment protect the individual from unjust accusations and proceedings, securing one's right to due process.
In the Fifth Amendment, the right to a grand jury, ensuring the presence of enough viable evidence to warrant a case, protects the defendant's character by preventing them to be subject to an unwarranted trial, which could unjustly hurt their character and public reputation. The right against double jeopardy prevents the same trial to be heard twice, ensuring a defendant's original verdict. The right against self-incrimination protects a defendant from committing perjury or unintentionally incriminating themselves.
In Miranda v. Arizona, the Supreme Court found that prosecutors cannot use statements stemming from custodial interrogation of defendants unless rights were enumerated beforehand. Finally, the right to due process ensures that proceedings follow established laws and regulations, ensuring equal and free treatment of all defendants.
The Sixth Amendment focuses on protections needed for trial proceedings. A speedy trial ensures one cannot be held for an indeterminate amount of time. Public trials allow for the people to oversee the courts, curbing government abuse. The right to a trial by one's peers prevents a biased jury by providing a collective group which represents various views and moralities, yet still adheres to the rule of law. Provisions in the Sixth Amendment ensure one's right to a fair trial by providing each criminal defendant with an attorney. Established in Gideon v. Wainwright, right to counsel is a fundamental right as it is essential for a free trial.
Limited government was implemented in order to uphold one's natural rights. By restricting the government, a citizen's rights are ensured at all times. Trial by jury ascertains that one's natural rights shall not be revoked arbitrarily or without government cause. As Thomas Jefferson articulated to Thomas Paine in 1789, I consider trial by jury one of the anchor yet imagined by man by which a government can be held to the principles of its constitution.
By also encumbering the government with the burden of proof in order to convict a defendant in criminal proceedings, the government is limited because they must convince the jury beyond a reasonable doubt that the defendant is guilty.
However, this notion of limited government has been lost as one's right to trial by jury has been infringed upon by the government. In 2011, the National Defense Authorization Act gave the military the right to detain American citizens, holding them indefinitely without trial, and granting the military the right to try defendants through military tribunals rather than jury of peers. Because trial by jury has been denied, the concept of limited government and natural rights is jeopardized.
Derived from English common law and first established in America in the Pennsylvania State Constitution, the founders felt the importance of a public trial in order to use the common public as a guard against judicial tyranny. They are vital in the criminal system because they enable the people to uphold established rights and laws by regulating the actions of government. Should trials occur behind closed doors, government could discreetly abuse rights and freedoms, violating fundamental principles in the United States.
Public trials also encourage civic participation by keeping the public informed about a trial's proceedings, therefore ensuring government accountability. However, media is also rebuked for sensationalizing stories and misinterpreting cases, potentially leading to the defamation of character of those involved. In 2011, the heavily publicized Casey Anthony trial turned public opinion against the later acquitted Florida mother, leading to death threats prior to, during, and after the trial.
Articulated by Justice Hugo Black in the 1948 case in re Oliver. Whatever other benefits the guarantee to an accused that his trial be conducted in public may confer upon our society, the guarantee has always been recognized as a safeguard against any attempt to employ our courts as instruments of persecution. Thank you.
Does the Fifth Amendment protect the right of a defendant to only be convicted beyond a reasonable doubt?
Well, a reasonable doubt is the highest standard in a trial, and it's essentially moral certainty by the jury's opinion.
Yes, in criminal cases. In civil cases, however, the burden of proof is lower, and it's not beyond a reasonable doubt.
Okay, you guys talked about public trials a lot. Are there negatives to having public trials, and if so, what are they?
Yes, a negative to a public trial is with the media being so high-tech as it is today, so instant, with Facebook and such. When there's a jury to when there's a jury of your peers, and unless it's 100% sequestered, there is really no way of saying that they have already had an opinion going into it. Unless they don't have their phone, TV, or anything, then they probably already have an opinion going into the trial.
And media oftentimes sensationalizes the trial, and which is seen in the Maxwell versus Shepard case, where in the trial he wasn't convicted of anything, yet the community had already posted newspaper articles saying, why isn't he in prison?
Furthermore, well, we were talking about the media being a drawback, and part of the media being a drawback to this is that they make the news of the cases very widespread, and so it's very difficult to find an impartial jury. And one of the guarantees is that you have an impartial jury, and a jury of your peers, but if you can't find that jury, then you're not guaranteed a case, a fair and just case.
Expanding off of what my colleague Austin said, when juries have been sequestered, such as in the O.J. Simpson murder trial, the jury being sequestered by the state of California eventually cost the state $15 million in order to keep the jury in a hotel for that length of time. And because of that, although like the public trial is incredibly necessary, the media has a huge drawback, as jury impartiality is far more important.
However, public trials are also very necessary, as my colleague stated, because it promotes limited government, and as seen with the Star Chambers back in the British government, they don't have the right to take away freedoms and accuse those who are innocent.
What's the difference between procedural due process rights, which are essentially guaranteed, I guess, in the idea of the Fifth and Sixth, and substantive due process rights?
Procedural due process rights are essentially the process that law enforcement needs to go through in order to take away any freedoms or life of the person they need, and it oftentimes includes getting a warrant.
Procedural due process rights were clearly delineated and expounded upon in Miranda v. Arizona, as far as how the police must go about informing people of their rights and informing them of their rights of due process.
Substantive due process rights are different in the fact that they might not be specifically enumerated, but they're based on fundamental principles and fundamental rights in the United States, and human rights in general. So these rights may not be written out in a process as due process rights are, but they are much.
Give me an
Common
example.
sense.
Give me an example. Give me an example. You did a great job answering. Give me an example. Loving versus Virginia. Here's all versus Connecticut.
Loving versus Virginia is based on this because the right to marriage is a fundamental right and cannot be denied.
Okay. Sorry, I just make an example.
How would you respond to people like, let's say I believe that jury trials are way too time consuming and costly, as she said with the $15 million OJ case. How would you defend this and persuade me to believe that they aren't really what they're worth?
Well, Nevada District Court Judge Mark Gibbons stated that it doesn't make any sense to have a jury trial when the trial is only fighting over $100 and the jury costs up to $5,000. That just makes no sense. And what he's saying is that it doesn't make any sense to have a jury of your peers when it costs more money to have the jury of your peers when it's worth over such little money.
I would disagree with what my colleague said, primarily because juries are the ones upholding the law in any trial case. They decide the decision whether the verdict is guilty or not guilty, and thus they are completely necessary, and anybody who is against it is therefore against upholding the law.
Although I personally feel that a trial by jury is necessary, in order to defend the point that maybe it's not necessary, is that 90% of cases are settled by plea bargains and never reach the court level. So if 90% of cases can be settled without a jury, then maybe there's the chance that a jury is unneeded.
And for that very reason, they no longer have juries in petty theft or petty crime cases where a crime can, or where a sentence would only be a maximum of 6 months.
Why 12?
12 is just a historical, funny thing that happened, quite honestly. It was ruled by the Supreme Court that, yes, historically it's been 12, but it doesn't necessarily have to be 12. It just has to be more than 6. Or it has to be 6.
When do police actually cross the line when it comes to a custodial interrogation and eliciting a confession from the defendant? What's that line?
Sleep deprivation for me. If
We have a weakness.
I don't know where you're going for here, so I'm just going with this. Sleep deprivation. A witness is not able to sleep and is constantly questioned for upwards of 16 hours and not allowed a rest period or a period in which to collect their thoughts, then the police have overstepped boundaries as far as rights, and you're making fun of
I'm
me.
not making
so-
fun of you.
Yes, you are.
Think about Officer Redmond.
Well, one clear violation would be if the Miranda rights are not read, and if a policeman does not give a defendant's clear rights then and still interrogates, then they are directly breaching law.
Stop there. Answer the question. Answer your own question.
You have the right to leave a custodial interview whenever you want.
No.
No?
Not
Which one's that one? Just wanna make sure. if I-
custodial mean once the
I'm
one.
confused, can I?
So the idea of the custodial once again is that you are not free to leave in a custodial interview.
Or you are not, you reasonably believe that you're not free.
Correct. You reasonably.
Yeah.
So that's when Officer Redmond said. Remember, what is he always says when you watch cop shows? It's the first thing they always do when they arrest somebody.
Am I allowed? Oh, really?
They Mirandize them, right? Unless they're gonna ask questions that are not, they don't have to Mirandize them. But if a police officer, Officer Webb comes in here and he starts going, "Hey, Tess, how's it going? What'd you do tonight? Where you been?" And you kind of avoid his questions a little bit. And you go, "Hey, Officer Webb, it's past my curfew. I need to go home." And he goes, "No, you can't go home." That's when a custodial interview has truly started. So.
So you have to basically ask.
But if you never
if you don't
ask,
ask, then it can be used against you. So therefore,
Correct.
the police are in the meeting.
and I think that's what this question is, because you could ask questions and you could you could feel free that you could have gone any time, but you really couldn't. You just decided to stay there and answer his questions the whole time.
And you know what? They may keep you awake. You never know.
Shit.
But I think to kind of, actually, that was a great example. I think there are multiple ways to get a confession tossed out. There's one, if the confession is, where they're not Mirandized. And then also, outside of that, just under the due process clause itself, if something is unduly coercive, if the methods of the interrogation tactics that the police use are unduly coercive, and that they lead to what we call an involuntary confession that's against their will, it's against the will. And it doesn't matter. It doesn't matter if it's true or not. It's just if it's involuntary, meaning in that they wouldn't have otherwise said it. So I don't know. I like that area. Well, I think also in-ray winship, IN_RE WINSHIP.
Wait, say that over.
In
Win, like as in
I won the game.
Charlie Sheen, win,
Oh,
and
okay.
then ship.
Charlie Sheen.
And
I
ship.
knew that was coming. Like, come on.
Winning.
Alright, in-ray winship, it's from 1970, it was a case, I think this is where they extended I could be completely wrong, but where they extended the reasonable doubt standard all the way down to juvenile proceedings, saying that it was also, because juvenile proceedings are effectively criminal, and that when you're talking about depriving somebody of life, liberty, or property, that you have to, in that respect, the state doing it like that, they have to have that reasonable doubt standard.
And what's the standard for civil? Because
That's preponderance of the evidence, 50% plus one way or the other. That's all it takes.
What is
That's why O.J. Simpson won his lost his
Because
civil
they
suit.
didn't have any
but
evidence, or as much evidence.
They didn't have to prove much. They just had to prove, it's like, the jury had to think, yeah, it's more likely than not that O.J. is responsible for their death.
somehow, some way.
somehow, some way, knife probably.
So it's the jury. It's a 50% plus one.
50% plus whatever small infinitesimal fraction, you guys could say, more likely than not.
Wow.
It's pretty
Yeah, probably.
easy.
That was going to be my question as well. So I mean, you guys need to spend a little bit more time on that one. Austin, on that first question, in terms of the media, what media outlet, what television media outlet do we have that follows trials all the time? And it's-
Nancy Grace.
well, yes, but not very many people watch Nancy Grace.
Thank God.
Great.
TMZ.
That's true.
I mean, in terms of the popularity of stuff, as soon as someone becomes popularized, whether it's Casey Anthony or some, TMZ is all over it, and it's boom, and then they go to the social networks. But there's that media outlet in terms of TMZ is all over. So I think that'd be a good way to answer that question.
I hate it.
So much.
Kat, if you're not totally sure on a question and you're trying to reach for it, don't do this at your teammates.
Wait, what are you talking about?
The first question, when you're trying to throw out court cases, you're looking at
Did
Kendall. Yeah, you're like, give me the power to give me the answer.
Give me the cannoli! What court case?
The very first question.
What did I say?
You were trying to pull out some cases. I don't know which case you're trying to pull
I
out.
don't think I was trying to pull anything.
You were.
No, but he's right that you do do that, actually.
No, I do that, because
Okay.
you guys know.
Stop doing
But I
that.
don't.
Stop doing that. Okay?
Apparently it's noticeable.
It is
I was gonna
noticeable.
tell you, I forgot to, like, last time too, you'd like tell me.
No, I just looked down.
No, don't worry. Haley did that with me last year. She'd just look at me and start saying like pornography, Reno, AC something. And she'd like start yelling at me, and I'd be like, oh yeah, I know what you're talking about. Just don't turn to me and say that. Just I see you say, yeah, don't do that.
Austin, that your quote you used for the
But you should
jury system, he didn't quit it. I mean, you were like,
I know.
just get it. It was great. Get it out.
So am I supposed to explain it after? Because I feel like it's kind of self-explanatory, but I
No,
wasn't sure.
nothing is self-explanatory.
So I should have been. Okay.
Give the quote. Explain what it means. Done. Okay.
Yeah, what was that?
My first question was, does a reasonable doubt, it is actually part of due process. It's technically a substantive and procedural due process right in a criminal trial to have an instruction from the judge to the jury on a reasonable doubt. That you have to, and it's that idea that you can't mathematize it, but it has to be something, it's to a moral certainty, or, I'm still picking on you for that.
I know, but you can help me with my closing for mock trial, because I'm trying to define reasonable doubt right now, and it's an
Awesome.
awful case.
Awesome, yeah.
Huh? Criminal, I'm closing for the defense, it's
Yes.
impossible.
No. What was the question before that? What was the question before the custodial question?
Was it me?
Yeah.
What was it? Oh, it was the too time consuming CASA.
Oh, yeah.
Juries.
Like our jury's 2
Are they not?
That's
you
not
say?
my actual belief, but I was
I
just.
said that anybody who thinks that is not for upholding the law, because juries decide based on the law.
Bring some example to that.
I didn't have a tool.
Okay, bring some example to that. You guys really need, I think you guys need to talk to you three a little bit about substitute process and procedurals.
Yeah, I had absolutely.
Yeah.
It took me a second, and then it
And,
did it,
and the
then-
big thing I'm waiting for, I'm just sitting here going Lawrence versus Texas, Lawrence versus Texas.
Yes.
Lawrence? No, it's a,
Mr.
yeah,
Clark, we have a question.
yeah.
I have a question about the 12 thing, first of all.
The what?
Can you, the 12 thing.
You were just like, why 6, 12?
Yeah,
Why call jury members?
And then
Right.
second,
Williams
because,
v. Florida, that's the Supreme Court case I was looking for.
Oh, why
Yeah.
jury member? We didn't even know
We
what
were
you
like,
meant with 12.
12, and we're like,
yeah.
Why 12 in a jury?
Okay.
Instead of 6?
Yeah, instead of whatever.
Oh.
Instead of 35.
What is the name of the case?
but really,
Williams
it's
v.
just
Florida, like the jury size of 12
Division, I don't know,
historic acts.
Wait, what is it?
I've never
The
seen
jury
it.
size
Florida
of
So the
12,
case.
Williams v. Florida.
And lesson 31 has a whole bunch of cases in terms of what the minimums, the maximums, they're actually in the lesson, so make sure to look at that.
like
Wait, what is it?
Lesson 33, 32? Yeah. It's 32. It's the last chapter, the last lesson is chapter 5. Okay, boom!
Alright.
Practice testimony.
Yeah.
Practice testimony.
Need to back
I think we
this
need
all
to
up.
reorder that.
Really?
I think we
I
did
think
better than our last one.
Yeah.
Like, directly in a line.